Welcome to Employment Law class. Today we look at Section 2 of Unit 5, Appointment and Authority of Agent. Session Objectives. By the end of this session, you should be able to explain how agents are appointed, identify the authorities of agents. You should understand that an agent is appointed by actual authority, or implied, which is the same as ostensible consent or authority. Here, with actual authority, the agent is appointed and given express duty or what he should actually do. For instance, A may appoint B to sell his property at a price of 100 Ghana cedis. So the A has given B or appointed B as agent to perform specific duty, that is to sell his property at this particular price. With implied or ostensible authority, here the principal intends either by word or deed that the agent should have certain authority, or by implication recognized by the principal to act on his behalf. So here, any performance that is incidental to the main duty of the principal, it will be said that the agent has implied duty to perform those duties as well. Let's consider other implied authorities. We have the issue of cohabitation. That's a presumption that where there's the presumption that the woman has authority to pledge the man's credit for necessaries. Here, it simply means that where a man and woman live under the same roof as husband and wife, it is presumed that the man has appointed the woman to pledge goods on credit, goods that are necessary on his credit. It means that the man will be responsible for those goods that are taken by the woman. The rule does not apply when it comes to man taking goods on credit of the woman. You could also analyze this from the fact that a partner in a firm has implied authority if he acts on behalf of the firm within the scope of partnership business. So the key word is within the scope. So it means that if the partner is not acting within the scope, he does not have implied authority. An agency or an implied agency may arise by estoppel. Estoppel, where the person by his conduct or words represents to another to believe that he has an authority to make contract on his behalf. To understand this, what we mean is that when one party, let's say A, allows B to believe that C has his permission, or he has given permission to C to act on his behalf, then A will be stopped from denying that fact. So the principal will be bound as if he had expressly authorized it and stopped from denying the agency relation. What basically we understand, basically what you can say is that, assuming your friend come to your store, you are there with your friend, you are chatting, and someone enters your shop. The person attempted to buy product from your shop, and your friend gave the price. Meanwhile, you knew that the price that your friend mentioned was not the exact price. You will allow your friend to sell the goods to the third party who came to buy the item. If the third party buys the item, you cannot later say that the price that your friend sold the product to him was not the original price. Your conduct has made him to believe that B has the authority to act on your behalf. That is why you didn't talk. So either your conduct or your words represent that a third party has your power to act on your behalf, and therefore you'll be stopped from denying that fact. So in the case of SOA v. Bank for Housing and Construction and another, it was held that if a party was ignorant that he had been named as an agent of a party in a contract, but nevertheless acted as an agent for that party, he would be stopped from disclaiming the status and the party would be bound by his acts. So the case of SOA v. Bank for Housing is also throwing more light on issue about estoppel. Agency is a contractual relationship in which an act of an agent binds his principal, provided he is acting within the scope of his authority, whether implied or actual. So as you were saying, the person should act within the scope of his employment or duty. And this can be either actual or implied. Actual means expressly given, or you imply by necessary implication. You should also understand that the agent by his action brings the principal into contractual relationship with the third party, and the maxim qui facit per alium facit per se. It simply means that he who does a thing through another does it for himself. So, normal example: A appoints B to enter into a contract with C. So the contract was entered into between B and C upon appointment of B by B by A to act on his behalf. Now the contract entered by B with C would deem that A has rather entered a contract with C, and A is bound by the contract entered between B and C. So there's a presumption that even though B acted on behalf of A in entering a contract with C, the principle or the maxim presume that A has entered the contract himself. By way of summary, we have attempted to explain how agents are appointed and the type of authority they have. Thank you and have a nice day.